I assume
Unless there's an issue.
I think it states one.
We're ready.
All right.
Here we go. All right, you may be seated. All right, Ms. Martin, call your next witness.
Your Honor, ladies and gentlemen, the defense rests.
All right, ladies and gentlemen, the court has prepared you some additional legal instructions. I will now read the court's instructions to you, then we will have arguments of counsel. Each side gets 20 minutes. The state will divide their time like they did last time. Court's instructions to the jury. Members of the jury. The defendant, Cedric Deshawn Johnson, has been found guilty by you of the offense of causing serious bodily injury to a child younger than 14 by omission. The court has received and accepted your verdict of guilty, and you will no longer concern yourselves with the guilt or innocence of the defendant, and shall now limit your deliberations under all the law and evidence in this case to the question of punishment, which is now your duty to assess. The punishment authorized for the offense for which the defendant has been found guilty is by confinement in the institutional division of the Texas Department of Criminal Justice for any term of not more than 99 years for life, nor less than 5 years. In addition, a fine not to exceed $10,000 may be imposed. Parole instruction. You are further instructed that in assessing the defendant's punishment, which you will show in your verdict, you may take into consideration all the facts shown by the evidence admitted before you in the full trial of this case and the law submitted to you in this charge and in the charge previously given to you by the court. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less, without consideration of any good conduct time he may serve. Eligibility for parole does not guarantee that parole will be granted. It cannot be accurately predicted how the parole law might be applied to this defendant if he is sentenced to a term of imprisonment, because the application of these laws will depend on decisions made by prison and parole authorities. You may consider the existence of parole laws. However, you are not to consider the manner in which the parole law may be applied to this particular defendant. You are instructed that in determining the punishment in this case, you are not to discuss among yourselves how long the defendant will be required to serve any sentence you impose. Such matters come within the exclusive jurisdiction of the Board of Pardons and Paroles. Extraneous offense instruction. You are instructed that if there is any testimony before you in this case regarding the defendant having committed offenses other than the offense described in this indictment, you cannot consider said testimony for any purpose unless you find and believe from the evidence that the defendant committed such other offenses. The burden is on the state to prove each extraneous offenses to prove such extraneous offenses or bad acts beyond a reasonable doubt. The prosecution does not have to prove extraneous offenses or bad acts beyond all possible doubt, but the proof must exclude all reasonable doubt concerning the extraneous crime or bad act. Therefore, if you find and believe beyond a reasonable doubt that the defendant committed an extraneous offense or bad act, then you may consider such evidence in assessing the defendant's punishment. If you do not so find, or if you have a reasonable doubt as to whether the defendant committed an extraneous offense or bad act, then you may not consider such evidence, if any, for any purpose. Fifth Amendment right. Every defendant has the constitutional right to remain silent. A defendant may testify in his own behalf if he elects to do so, but this is a privilege under the law, and if he chooses not to testify, that fact cannot be held against him. In this case, the defendant has elected not to testify, and you are instructed that you must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Instruction regarding bias. You are instructed that jurors must be able and willing to make careful and impartial decisions that are not based on bias or prejudice. Do not let any personal bias, prejudice, sympathy, or resentment on your part, or any such personal emotion on your part, enter your deliberations or affect your verdict in the case. All persons deserve fair treatment and equal justice under the law, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You must set aside your own personal biases and prejudices during your deliberations and base your verdict on the evidence. Decisions based, either wholly or in part, on unfair stereotypes have no place in a criminal trial and will taint any verdict which is not based solely on the evidence and these instructions. Evidentiary instructions. You are the exclusive judges of the facts proved, the credibility of the witnesses, and the weight to be given their testimony, but you are bound to receive the law from the court, which is included in this charge. Your verdict must be unanimous, and after you have arrived at your verdict, you may use the attached form by having your presiding juror sign the correct verdict. You are instructed that any statements of counsel made during the course of the trial or during argument not supported by the evidence, or statements of law made by counsel not in harmony with the law, as stated to you by the court in these instructions, are to be wholly disregarded. You are instructed not to use any cellular device, smartphone, computer, or tablet during your deliberations. If you have a verdict, or if you wish to take a break, turn on the red light and the bailiff will quickly respond. Signed by me, Nancy Mulder, Judge presiding, Criminal District Court 6, Dallas County, Texas. Here is the verdict form. It reads, "We, the jury, having found the defendant Cedric Deshaun Johnson guilty of the felony offense of intentionally or knowingly by omission causing serious bodily injury to a child, as charged in the indictment herein, we assess the punishment of the defendant at confinement in the institutional division of the criminal justice system for blank years. Enter a period of time of not less than 5 years or more than 99 years or life." And if you wish to assess the optional fine, and a fine in the amount of blank up to $10,000 or none, there is a place for the presiding juror to sign and then print her name. We will now have arguments of counsel. Mr. Zacharias, you may proceed.
Thank you, Judge. May it please the court, opposing counsel, members of the jury. Okay, we're at that time now. So I'm showing you the last page of the verdict form. There's a space here, that gap right there. You guys are going to decide together unanimously. Okay, you guys will get together again and decide. You'll put either a number between 5 to 99 in that space, or write the word life. That's what we're asking you to do in this case. Okay, you're going to put you guys come together as a group and decide. Hey, what are we going to make in this situation? That next line here is for a fine. I will tell you, I want to be really clear. I know it came up in jury selection, but I want to remind you guys that fine does not go to the family or anything like that. So fines that's why the judge sort of just made a comment about the fine as well, if you feel like paying a fine, right? Because you don't have to, it's not required. If you feel like it, you can. But I just wanted to be clear about that. That's what those are two lines. First line here, a number between 5 and 99, or the word life. And then the second part here, $0 to $10,000 fine. But again, remember that fine doesn't really go to anybody other than the state. Okay? All right. So the other part I wanted to cover with you guys is parole law. I don't know if you guys heard Judge talking about that. Parole law is, so if you guys were to say life, theoretically, they become eligible for parole after 30 years. That doesn't mean they get parole after 30 years. And so that's why, so 99 years, 60 years, and still 30 years is what would come out. If you said 50 years, you would be eligible for parole, not that you would get it, but after 25 years, half time. Okay, so it's either half or 30 years, whichever is less. Okay? So I just wanted to be clear about those things. But to be clear as well, in the very next paragraph after they say that, it says very clearly, you are not to consider the manner in which parole law may be applied to this particular defendant, because we have no way of knowing. So you guys can't think about that when you get back there. Don't consider parole law at all. It seems really weird. I just talked to you about it. It's written in this document, but then they tell you don't think about it. Okay? But don't think about it. It doesn't matter. That doesn't come up. You all have to just come up with a decision, 5 to 99 years or life. Okay? That's what y'all have to do when you get back there. All right. Those are really all I want to talk about in the charge. So, if we were here just because of Cedric Johnson and what Mr. Johnson might want to happen, or if we were here just for Serenity Johnson, or Zion Johnson, or Eliana Johnson, or any one of the other kids, and how they feel about the situation, that might be one thing that you guys would want to do. They're not the only reason that we're here. We're here for CJ as well. We're here for what Cedric Johnson did to CJ. We're here because Cedric Johnson decided CJ needed to go into a dumpster on July 10th, 2019. That's why we're here. We're here because CJ's family is sitting right there watching all this go down. Because CJ's family has been here going through this just like that family, the Johnson family has, for 6 years now. 6 years without CJ in their life. 6 years that the oldest of Latricia's grandbabies is like, I miss my best friend. Right? That 10-year-old, her oldest grandson, still misses her, still misses the younger CJ. We're here because that family is struggling. We're here because CJ is not here anymore. We're here because it's not just, people always talk about, oh, whenever we have a case, oh, are you my lawyer when we call the victim's family? Are you my lawyer? No, I'm not. I'm a lawyer for the state of Texas. I'm here as the state of Texas. Ms. Burris is here as the state of Texas. That's also what you have to consider. What is it the state of Texas wants? What is it we as a community want for someone who puts an 18-month-old child in a dumpster? What is it we as a community feel that someone who puts an 18-month-old baby in a dumpster deserves? It is a super hard thing y'all are about to go do back there. But y'all promised y'all would follow the law. Y'all promised y'all would be able to do it. And we're trusting you guys to do the right thing.
You may.
Ladies and gentlemen, we're here without a lot of people. Because in a case like this, I think when I was speaking with one of the members of the family of the victim's family, and by extension the children of Cedric's family, this is like a nuclear explosion that happened in this case. Everybody in 4 sets of families has been impacted. And you can't focus on one particular thing in the punishment phase. In the punishment phase, you have to weigh every little bit for what you heard. And the charge says you are the judges of the weight to be given to each of what the testimony that you heard from all of the witnesses. And you can give more credibility to one person and more weight to what one person said than the other. And And I imagine that the state's going to get up here and says, what's the value of a child's life worth to you? And that's true. You do have to weigh that. But you also have to weigh, because of this nuclear explosion, what's the value of the rest of Mary's life? What's the value of the victim's family? To be fair, to be, you have to weigh it all. And what's the value of the children's lives that Cedric will continue to leave behind once you put that number on the jury? Remember, he's going to live with this every moment forever. So that number that you put on there is a number. But for him, it's forever. Miss Mary told you that he is never going to forget. He is incredibly remorseful. She says he cries all the time. Not for himself, but for the baby, and for that baby's family, and for his own. His terrible decision that night for him. We will all agree with that. But what you have to remember is the decision that you make needs to be based on the charge as well. He was charged with failing to seek medical attention, and that resulted in the child's death. He was not charged or convicted with murder. He was charged with not seeking medical help. Because remember from the statement, he told you all, he did every single thing he could to try to save him. Every single thing he could. He loved that. Miss Mary loved that. So what is it for? All of those things need to come together when you're making a decision. And that number, whatever it is, does have to be unanimous. That means all 12 of you have to agree on that one number. Okay? I want to make sure, because people, every trial when it happens, when we go back there, somebody sends a note out and says, oh, do we all have to agree on the number? Yes, you all have to agree on that number. Okay? No question, you all have to be the same number. Now, Mary's words to you about all of the good that he did should not be thrown away. That's something that you should also consider. He was a member of his church. He participated in church before he got to the jail. He took care of the children. He cared for his children. His children got up here and told you how much they loved him, how much they missed him. And they all know that he's going, from here, he's going to go to prison. We all know that. Based on your verdict, we all know that a number is coming. But what we have all asked from the defense side is to show him some grace. Because that's where we're at. We're asking for grace from you. Let his family know that there is a light where they will be able to see him again, where they will be able to touch him again. Because at the jail, there's no touching. Behind glass is what Zion said when he testified on Wednesday or Tuesday. He's been in jail for 6 years. He has not been out living life, having a good old time. He has been locked up already for 6 years. And I think that means something. He knows what's coming. Based on your verdict, he knows he's going to prison. And maybe the prosecutor gets up here and says, start here at the highest number and work your way down. And I'm not going to say start at the bottom and work your way up. That's not what this case is about. This case is not one of those things where you put, where we say, this is what you must do. I'm not going to do that. What I'm going to ask you to do is really think about what you heard. There was love in that house. There was caring. There was fun. And one night things went way off the rails. And a horrible thing happened. And I know I told you may hate what he did. You may even hate him. But it's not worth a life sentence. Because he's already going to be serving that in his life. Really think about what you need to do. This is a hard one. It really is. You know, Mr. Yeager from the landfill told you that no one can possibly imagine that's what would happen to your body. There's no way anybody could have known the damage that Senator Jr. was suffering. Nobody would know. And I know Mr. Zachariah said he, threw him in the dumpster, he threw him away, but he didn't know that is what would happen. He didn't know. And he's cried, and he's been remorseful, and he's felt terrible. And we've heard that through the witnesses that we brought in. He will carry this with him for the rest of his life, till the end of days. But that number should take into consideration all of the other people, including his children and his grandmothers. What number is appropriate? Is it 10? Is it 15? For not seeking medical attention? Because that's the question you have to ask. He didn't seek medical attention based on your verdict. So what is that charge worth? And you've taken in all the other things. But at the end of the day, he has been charged with not taking the baby to the doctor. Not intentionally killing him. That's very important. You need to make sure you think about that. Because he didn't try to kill him. He didn't knowingly want to kill him or know he was killing him. He was trying his best to save him. Please remember that when you go back. We thank you for your time this week. I know this has been hard. I know this has been rough. I know that you've seen things that you'll probably never unsee. We thank you. We respect your verdict. We respect all of the hard work that you've given to this process. And we ask you for grace.
Thank you, Ms. Martin. Ms. Burrows, you have 11 minutes.
Thank you, Your Honor.
Yes.
Remorse. True remorse. What does that look like? What does that look like after you've done something wrong or bad? I'd submit true remorse doesn't look like waiting until a couple of months before trial to start calling the kids and seeing if they're going to be on your side or not. True remorse doesn't look like exposing the evidence. True remorse doesn't look like lying to police, to CPS, to Crystal, to his mom, and another one who raised him. Because at the end of the day, you are here to decide what this is worth. And you are here to decide that. And make no mistake about it, ladies and gentlemen, everything that you have seen and heard over the last 7 days are the actions of this man and his choices. No one else made a choice to be involved in this. No one else woke up and wanted to be doing this. You've heard that from almost everybody who came up. His choices are the ones that kept him from his children. His choices are the ones that affect his son. And his choices are giving that family a life sentence. It's not anyone else's fault but Cedric Deshawn Johnson. And his choices, let's talk about him. Why did he? Do CPR? Who became the time to revive? And then let them know. I submit to you it's because he's the one who put that baby in distress. I don't know what happened to CJ on July 10th of 2019. I told you that from the very beginning. I have no idea what happened to that baby. What I know is that baby started throwing up, if I'm to believe the defendant's statement, and I think he said some of the truth. I don't think he told all of it. But that baby was in distress. It was so much distress that he needed to perform CPR. That doesn't happen by accident, ladies and gentlemen. We don't just all of a sudden stop breathing. Something happened to do that to that baby. And that is why he didn't want to get the police involved. Why he didn't want to bring medical attention. Because that would have brought attention to him and how the baby got there. A reasonable deduction as to how we find ourselves here. I can't prove that. I don't know. Because when we finally found CJ, I couldn't tell what was more. And I'm sure that this defendant had no idea that when we found CJ, we wouldn't find a full CJ. But he certainly knew that putting in the dumpster like trash was not going to yield a positive result. Because we do need to talk about why we're here, not just what we heard today. We talked about in your jurisdiction, in your juror questionnaire, right? We talked about what's important in punishment. We talked about the facts of the case themselves, and we all checked that was important to you. And that is why we're here today. And his choices that he makes. And the reason that I asked some of those questions of those witnesses, right? Because his choice to lie, right? Miss Mary, who doesn't love Miss Mary, right? I want her to be. So what did she tell me? And I asked her specifically about the Xbox. Why? Because he brought that Xbox to his mom's house and hid it. And previous to this idea that someone took the baby and after the Xbox. So he's the one who removed it and put it in Miss Mary's house. She was surprised as police were that they found that over there. What does that tell you about his remorse? I'd submit to you that when he cries for him. He cries for himself. And I think he probably feels pretty bad that Serena feels pretty bad. Without being crying for him. Any tears that he cried are not for CJ. They're for himself. Ms. Martin said that I would probably say, let's get on with the life, and that is unfortunately what we have to talk about. The value of CJ's life. Because that's, in the end, what we're evaluating today. That beautiful 18-month baby. And you're not on that one thing. What is their problem? Just the fact that he walked his kids to school, is the fact that he watched them do what they're supposed to do, what every other parent on the planet does, Does the fact that he did those things, does that offset what he did to that lady? Does that change for DJ or his uncle or his grandma? That they can never put arms around that baby again? Because they are serving a life sentence. Their family was forever wrecked by his actions or inactions, whichever way you want to look at it. There's a 10-year-old who cries about a baby. All of these children were exposed to something far beyond their years that they never should have been exposed to in their life. His choices. So what am I going to ask you to do? I'm going to ask you to show him the mercy and the grace that he showed him. What mercy and grace did CJ give? Did he get any? Mercy is for those who deserve it. And grace is for those who don't. And this defendant has done it. He has done it. He has lied. He has covered up. And he is only concerned about saving himself.
Your 3 minutes.
The mercy that he showed CJ, the grace that he showed CJ, that there was none. So I'm asking you to show him equal, like his life, and to show him none. And let him know that his actions forever changed everyone's lives. That they were his. Sentence him to what he sentenced CJ's family to. A life sentence.
All right, ladies and gentlemen, jury, you'll retire to the jury room and begin your deliberations and punishments.
All right.
You may be seated. Marissa, if you could get the evidence together with the exception of the discs.
All of it.
No. Let me get us all.